Good afternoon, Terps. My name is Jeff Williams, the Director of Alumni Engagement at the Smith School of Business. Today's webinar is part of the Smith School Office of Alumni Relations Professional Development Webinar Series. Through these sessions, we hope to provide thought-provoking and valuable content that will help alumni and Terps like you achieve your personal and professional goals. Past topics include how to succeed in a future transformed by technology, employee versus independent contractor, what is the difference and why it matters? And today's topic, why you need an estate plan regardless of your age. During the webinar, we encourage you to use the chat box to share any questions or comments you may have for the presenter. Please feel free to submit questions throughout the session, and our presenter will answer them as often as possible. And who is our presenter? I am pleased to introduce Raj Goel. Raj is an equity partner with Offutt Kerman, PA, a mid-sized law firm with offices throughout Maryland, and is the chair of the firm's Estates and Trust Department. Raj's legal practice has been focused on assisting professionals and business owners with their estate and tax planning needs. Active in the Harford County community, Raj has served on the operating boards of a number of nonprofit organizations, including a one-year gubernatorial appointment to the University System of Maryland Board of Regents. Raj is a proud double Terp, graduating with his bachelor's and JD. I will now throw things over to you, Raj.
Jeff, thank you so much for that introduction. That's very kind of you. Good afternoon, everyone. I'm very pleased to be here to talk about why you need an estate plan with the parenthetical statement, regardless of your age. It really is my hope that regardless of your status in life, your age, whether you're thinking about retiring or just starting working, that everyone's going to get something out of this. And of course, one of the big dilemmas I have is that we're not talking about the most compelling of topics because it forces us to talk about topics that we all would rather not deal with, because it requires us to face the reality of the day that we're no longer able to make our own decisions, the day that we're no longer able to care for ourselves, and of course, the day that we pass away. And I think most people find that they realize and recognize the importance of having a good estate plan, but oftentimes the issue is, how do I get started? What are the questions I need to be thinking about? And just what is the best way for me to best protect my family? So I'm really hoping in the time that we're together that we'll have an opportunity to provide you that information. And for those of you that are on the line that perhaps have an estate plan, I'm hoping this will be just as beneficial to you in helping you think about whether your estate plan is in fact up to date and whether or not some updates and revisions may be necessitated. So with that being said, let's get right into the presentation itself. And in terms of the introduction, I think it's always helpful to talk about what estate planning is and what estate planning is not. And what I mean by that is that many people think that estate planning is a bunch of forms where you fill in names and sign here and voila, you have a great estate plan. And what I think you'll appreciate, if you haven't already appreciated this point, is that by the end of this session that you should have an understanding that estate planning is a very thoughtful process. It's not one where you just change names. It's one that advisors such as like myself, accountants, financial planners, oftentimes working together, will want to understand your fears, your concerns, your goals. And it becomes very customized in terms of understanding the objectives, your family dynamics, your situation in life. And I can talk with 10 different families, and that will result in 10 different customized estate plans. And that really is the nexus of what makes and distinguishes a good estate plan from one that really is a boilerplate and oftentimes is not effective, and most of the times don't even achieve the intended result. And as you can see from the slide that's in front of you, most people say, do I really even need an estate plan? I love my kids, they love me, and I have no doubt at the end of the day they'll be able to figure this out. That's a common refrain I'm sure many of you have heard. But I think you've also appreciate that the stories that you've heard, maybe even in your own family, of disputes and disputes that go into court, and hundreds of thousands of dollars being spent in legal fees fighting over some of the most trivial of issues, all because the issues were not delineated and addressed at a more timely fashion by the person who just became incapacitated or who passed away. So again, that's the importance in what we're talking about. And now with that transition, let's talk about the different aspects of a good estate plan. And I think that when we think about estate plan, the most common document that people immediately think of is the will. And I think most people conceptually understand what a will is. In essence, the piece of paper that delineates how I would want my assets to be distributed at the time of my death. And of course, many times the common question is, well, what happens if I pass away and I don't have a will? Many people have the misconception that the government will come in and take all the assets. And in fact, what happens is that depending on the state of your residency at the time of your passing, that state will actually have a set of laws called the laws of intestacy, wherein they will define who will inherit your assets at the time of your passing. And most times they look at your closest living blood relatives. So for most of us, perhaps that's what we have in mind, but in most situations you'll find that people do have other thoughts and wishes, and those will not be recognized by state law. So if you want to have more control over the disposition of your assets, that's what a will is all about. But even more fundamentally, and this is where the big gotcha moment occurs for many of my families, that keep in mind that a will only controls assets that are titled in a person's sole name at the time of their passing, meaning that there's not a joint owner or a beneficiary that's designated to that asset. Because if there is a joint owner or beneficiary designated to that asset will automatically go to the surviving joint owner or beneficiary regardless of the terms of the will. So let me give you and share with you a story that literally occurred 2 weeks ago. Elderly gentleman comes to my office and unfortunately lost his wife about a year ago, has 3 kids. The superstar child, who's the eldest, the second child sees only in the holidays, and the third child, well, that's the one that's been on the couch and haven't seemingly got his act together. And he said, you know what, Raj, I'm going to name my eldest child as my joint owner on all my accounts. So if something happens to me, she'll be able to take care of my business for me. And I say, sir, I totally understand your goal here. But do you understand that at such time that you pass away, all of those accounts will go automatically to her as a surviving joint owner, yet your will says you want everything to go a third, a third, a third. And of course his response was, oh, well, she'll split it with the other 2. And if she does, okay, fine. But if she says, you know what, I deserve that money, and she rationalizes it in her own mind that she's deserving of that money and doesn't split it with the other 2, well, I'll tell you right now, that's the source of a lawsuit. So my point is not only having a will and the importance of delineating how you want your assets to be distributed, but how your assets are titled are of critical importance. And as we think about a will, the other aspect that I find that of great benefit in discussions such as this one is that when I sit down and get to know someone, they quickly can identify the people that they ideally would like to leave assets to. But the reason that they hesitate to go any further in this process is they say, well, and I've set forth a list of some of the common concerns. Well, I'd like to leave money to so-and-so, but they're really bad with money. And it could be because of their age, it could be because of immaturity, or I have a beneficiary and I'd like to leave money to them, but they're disabled and they're receiving public benefits. And if they were to come into an inheritance from me, I'm concerned about the impact it would have on them. Or I'd like to leave money to somebody, but they're a physician or they're in a profession that makes it more likely than not that they may be sued. And I would hate to see my hard-earned money being lost to the lawsuit. And this is the big one. I love my children, but man, oh man, I would never want money to go to my son or daughter-in-law. Because if they get remarried, and you can fill in the blank, I'd hate to see the money that I worked so hard for going outside of the family line. And I would much rather see that money being left to my other children, to my grandchildren, my nieces and nephews. And the list goes, on in terms of the concerns that people express. And in a very most simplistic way, when you have a will, you just set forth the people that you want to benefit from your estate and the percentage or the specific dollar figure that they would receive. But if some of these concerns are relevant in your situation, one of the more common techniques that gets utilized is instead of leaving an inheritance outright to that individual, we will leave it into a trust. And what a trust is a legal entity wherein we say, under the terms of the will, that instead of leaving the money outright to this individual, I will leave this money to a trusted individual or entity. It could be a family member, it could be my next door neighbor, it could be my best friend, it could be my advisor, like an accountant or an attorney, it could be a bank, financial institution, corporate trustee, and their job and role as a trustee is to see to it that that money is utilized for the purpose of benefiting the person that you intend to take care of, that being the beneficiary. So for a lot of my folks on this line, I know that you're just starting in life, and starting your family, having young children, and a very common approach is that if I'm a single parent, or myself and my partner or my spouse, we both pass away, we want the money to go to our children, but because of their age, we're greatly concerned that they wouldn't be able to properly use and manage those assets. And of course, the common refrain is, if they come into money when they're 18, even in their early 20s, instead of utilizing that money, we're concerned that the beneficiary is going to make it party time. Buy that car, go to Vegas, and do everything that we would not want them to utilize with those funds. So what would happen is that under the terms of the will, we would say that we would leave this money to, again, a trustee, and their job is to ensure that those funds are used in ways that we set forth under the terms of the trust document, again, which is set forth in the will. Things like pay for their education, such as giving them the opportunity to travel, to go to camp, and to have all the necessities to ensure that they have the best quality of life, but not to go overboard and to purchase items that are extravagant, and certainly not to purchase items that would be detrimental to fostering a good work ethic and making sure that the child becomes self-sufficient and independent. So that's the beauty of a trust. It's control from the grave. It allows you, even though you've passed away, to ensure that your funds are utilized in ways that would be beneficial to your loved one. And of course, like anything in life, there's always pros and cons to everything. Now, I've set forth how trusts can be used very effectively for your family, but unfortunately, trust can be complex. And as this slide delineates, that a very simple will, which could be several pages, can very easily go to 29, 30 pages to set forth all of the parameters, because after all, we're talking about an entity that could be around for 10, 20, 30 years, sometimes many more years than that. And so there's a lot of provisions that need to be incorporated to ensure that your wishes are proper set forth in terms of how the funds could be used, but more importantly, to give the trustee, the person responsible for managing those funds, with the appropriate authority and power to ensure that they can carry out your wishes when you're not here. And of course, when we talk about 30-page documents, guess who charges more for it? That's right, guys like me. So there's a complexity, there's a cost associated with that needs to be justified. So my point in raising this is not to say that trusts are for everyone, because trusts are certainly not for everyone, but it gives you food and things to think about to see whether or not this concept makes sense, and if so, it could be a wonderful planning device. So with that being said, the other aspect, and again, this will pertain to those of you that perhaps have an estate plan and perhaps have already incorporated a trust as part of your estate plan, or for those of you that may eventually do an estate plan, and especially for those of you that are setting up trusts for young children, and you're concerned that you may pass away at a time when your children are minors, or certainly not of the age that they can properly manage assets. So again, the concept of trust would make a lot of sense. But there's also a trap that I find that unfortunately gets repeated time after time after time. And here is the example that I utilize. I have, and again, this is a story, this happened more recently, probably about 6 weeks ago, that I have a client that walked in and they had done their estate plan several years ago, and they came in feeling, Raj, we feel pretty confident that we've got things pretty buttoned up well for our family. But on the advice of our accountant, and just because it's been several years, we really would like to have someone take a look at it. And rest assured, and I told them, you have wonderful documents. They are set forth properly. They encapsulate everything that you want. But Mr. and Mrs. Smith, there's something that caught my eye. That I looked at the designation of beneficiaries for your life insurance policy. And here you're contemplating that if you were to die, that the life insurance proceeds would be distributed to the trust. But I see that the beneficiary designation is your children. Now, folks, you remember at the outset of this presentation, we talked about that if you have a beneficiary, if you have a joint owner, it will automatically go to that joint owner or beneficiary. And we don't look to the terms of the trust. So in this case, the beneficiary of the life insurance were the children, which means that at the age of 18, they would get the money. And back to the concern we have, it's party time. So I explained to Mr. and Mrs. Smith that instead of keeping the children as the beneficiary, we actually need to get a change of beneficiary form and actually put the verbiage that designates the trust under my will for the benefit of my children as the beneficiary. And that way we have better coordination with the beneficiary designation with the terms of the estate plan to ensure that if I pass away, the proceeds will not be given to the children, but in fact will be distributed to the trusts, which will then allow the trustee to manage and control those assets and to utilize that for the benefit of my children in the way that is prescribed under the terms of my will. And as I said, that's a big gotcha moment that a lot of people feel that they have covered, but where it breaks down is that the extra step of updating the beneficiary designation never occurred. Folks, as I said before, the titling of the assets is of critical importance and cannot be looked upon isolated and separate and apart from the estate plan. They have to be coordinated. So as we continue with the discussion of wills and unfortunately either ourselves or a loved one passing away, we unfortunately also have to deal with that dreaded T word. And that T word is taxes, and more specifically, the death tax. And I find that there's a lot of misconceptions about death taxes, and I thought it would be worthwhile to take just a few minutes to talk about what specifically are the death taxes and how do they work and whether or not that would be relevant to your particular situation. So the first tax that we speak about or talk about is called the estate tax. Now the estate tax is imposed on the recipient or on the person who just passed away. And what happens is that both the IRS, and assuming that you're a resident of Maryland, but again, whatever state that you're domiciled, that the government will look at everything that you owned on the moment that you passed away. meaning the value of your house, the value of your bank accounts, the value of your IRAs, 401ks, thrift savings plans, and in many situations, the death benefit from a life insurance policy. Now, you might be thinking to yourself, well, wait a minute. I have an IRA beneficiary. I've got a designation to my IRA. How can that be counted in the bucket? Well, the beneficiary designation just tells me who gets those funds. But literally the second that you pass away, you still had ownership and control over that IRA, and that's why it's put into the bucket of calculating the value of your estate for the purposes of estate taxes. Now, for those of you that have been following things in Congress and the progression of tax bills, will recognize that we have what's called an exclusion, what I call a coupon, that you need, and the value of your estate needs to exceed this coupon, as I loosely call it, before these taxes come into play. And I've set forth that in the slide that for the purposes of the federal estate tax, that threshold currently is $5,490,000. And one of the other things that I have not mentioned is that if you're married, with proper planning and proper processes put in place, that taxes typically do not come into play on the death of the first spouse, but on the death of the second spouse. And again, with proper planning and following certain processes after the death of the first spouse, that will allow the family to actually use both exemptions, which effectively allows a married couple to exempt $11 million from federal estate taxes. Now, to the extent that you have exposure above and beyond the $11 million, the tax bite is a fairly onerous one. We're talking about a 40% tax rate. And to transition from the federal back to the state level, many states have, and Maryland being one of them, do have a state estate tax, because Maryland says that's a pretty good gig. So they calculate the value of the estate in the same way does the IRS, but there the thresholds are different. For many, many years, the threshold has been at $1 million. But because of legislation that was passed several years ago by the Maryland General Assembly, that threshold is currently at $3 million. And that threshold is actually due to increase to $4 million on January 1, 2018. And then on January 1, 2019, it will actually become the same as the federal government, meaning if I'm a single individual, I'll be able to shelter close to $5.5 million. And if I'm married, I'll be able to shelter close to $11 million. So for those of you that are residents of Maryland and perhaps have exposure to the Maryland estate tax, my best advice is just hang in there for another year or two, and hopefully the exemptions and the increasing exemptions will eliminate your tax exposure. Needless to say that for those of you that have exposure above and beyond, and statistics show that with these higher exemptions, and these are the highest exemptions we've ever had in the history of tax law, and of course there's a lot of talk even now to completely eliminate these taxes altogether, which will be an interesting debate in Congress over the next coming months. But for those of you that do have that exposure, needless to say, there's a whole slew of planning that can be utilized to reduce, if not completely eliminate, that tax liability. And of course, that goes beyond the time that I would have in a presentation such as this. And again, my strong recommendation is to seek professional and your guidance from your team of attorneys, financial advisors, and accountants for proper advice on how to eliminate, if not reduce, your tax liability. So I think that that's, will be the extent that I'll talk about for estate taxes, and that will then transition to the second death tax called the inheritance tax. Now keep in mind that estate taxes and inheritance taxes are completely different taxes. Estate taxes are imposed on the person who just passed away, and again, with people that pass away with too much money. The inheritance tax, on the other hand, is imposed on the recipient, the person who's about to come into that inheritance. And on the assumption that the majority of people are based in Maryland, because this is a state-by-state law, that, focusing on Maryland for just a moment, that Maryland actually has a very favorable structure, meaning that if the recipient is immediate family, spouse, parent, child, stepchild, grandchildren, sibling, they will not have to pay any inheritance tax. It's only when the recipient is like a niece or nephew, a friend, then there'll be a 10% inheritance tax. And when we talk about what state law applies, we do not look to where the recipient resides. We actually look to the person who just passed away. Where were they domiciled? Where were they a full-time resident, being more loose, at the time of their death? And we look at the source, and if they were residing in Maryland, then Maryland law would apply, and even if all of the beneficiaries reside in California, Maryland law would apply. If the individual who passed away was domiciled in Pennsylvania, for example, and my recipients live here in Maryland, then Pennsylvania law would apply. And just by way of example, money going from a parent to a child is subject to Pennsylvania inheritance tax at the rate of 4.5%. So by and large, for most of my families, if the overall value is underneath $3 million, and that number, as I said, is going up, and it's going to immediate family, we should not have to worry about any type of taxations. And I should also add, a lot of people mistakenly think that if they come into an inheritance, that somehow that's considered to be income to them. So if they inherit, theoretically, $500,000, and they get a check for $500,000 from the late parent's estate, that somehow they have to report that as $500,000 of income on their income tax return. And let me just dispel that notion that an inheritance, by and large, is not, I repeat, not income that needs to be reported for the purposes of income tax. So now that we've talked about the issues of taxation, I just want to talk about just two other issues as we talk about and complete the concept of wills and ensuring that our assets can be properly distributed at the time of our passing. And the first of those two concepts is a very common question about, well, Raj, I hear about that I need to have what's called a revocable trust. I need to have what's called a living trust. That's terminology that are interchangeable. And how does that fit into it? And what's the difference between a living trust and a will? And it's a very good question, and it introduces our concept of what's called probate. That if I have assets titled in my sole name at the time of my passing, meaning no joint owner or beneficiary, that before those assets can be distributed under the terms of my will, we have to go through a court process wherein the court will appoint an executor, more formally known as a personal representative. There are papers that need to be filed with the court. There oftentimes are accountings, notices sent to various family members, a notice placed in the newspaper, and that process can take several months, 6 to 9 months to be more precise. And then there are a variety of fees, both to the court and if you hire an attorney to help you, legal fees. And a lot of people say, gosh, I really want to make this a lot easier for my family. I don't want them to have to go through the paperwork. I don't want them to go through the time. I don't want them to have to go through all that expense. So Raj, can you help me put together a plan where my wishes are honored in the same format that we've been talking about up to this point, but to avoid that probate process, to make this more seamless for my family? And the answer is, of course. Now, what a revocable trust is a trust that you actually set up now while you're alive. And you often, now we talked about trust in the context of that somebody else is in charge and that they'll dole out the money to the ultimate beneficiary. This is a little bit of a different type of trust. And the reason I say that is that this is a trust that you set up for yourself that you are in charge of, and you can pull money anytime that you want. You're in full control. And by the very name revocable, that you can change it, you can get rid of it, you can do whatever you want with it during your lifetime. And by having the assets, now the key there is that when you set up that type of entity, that we actually would have to change the titling of the assets from your individual name to that of the trust. And at such time that I pass away, because I'm not the owner of the assets, the trust is, it will allow the assets to automatically be distributed to my family, again, exactly the ways that we've been talking about up to this point, but without having to go through the time-consuming, costly process called probate. Now, on the face of it, that sounds great. And people say, Raj, that sounds like something that everyone should do. And of course, like everything up to this point we've talked about, when I give you the good, there's always the bad. And we've already talked about some of the bad in the context of trust. They're complex documents. Instead of having a simple will, you're going to have a very complex 30-page trust, sometimes longer. You're going to pay more for that. You may not understand all the terminology because of the dense legalese that's contained in that document. And then you have to take the time and expense of going to the bank and getting the deed to your house updated and updating the brokerage account titling to reflect that you no longer are the owner, but your trust is the owner. Again, you're still in charge of it. You still have control over that asset. But that's a lot of work, and that takes time. And a lot of people just would rather not deal with that and say, look, it's just paperwork. It's time. My kids can do it. They'll get professional advice. And I will tell you, a lot of people are out there saying you have to avoid probate. It's the worst thing in the world. And in some states, I will tell you that's exactly the case. But if I think about, again, using Maryland as our baseline, probate is not the worst thing in the world. Sure, it's paperwork. Sure, it's time. Sure, there are some fees. But one of my colleagues at the office, I think sums up in a good way. And there was an old commercial. This commercial would be probably recognized by some of the folks that are older on this call. The old Monarchy commercial. You know, pay me now or pay me later. So if you want a revocable trust, you can set that up now, but again, it's going to be more complexity now, more cost now, but on the back end, it's cheaper and it's easier versus, I'll keep it simple for now. I may change my plan in any event. I may move. So why lock myself into a more complex plan? But if I'm wrong and something happens, I know there'll be some more work and time and expense for my kids, but they're up for the task. And again, it's not the worst thing in the world. So my point is that trusts are not for everybody, but it's a worthwhile, thoughtful exercise to think about whether or not this makes sense. And of course, there's a lot of benefits to avoiding probate. There's also other considerations like privacy. It really does make a lot of sense to have a revocable trust if you have property in multiple jurisdictions, you know, property in Maryland, Virginia, and Florida. There's a lot of benefits that would come from a revocable trust, but my point that there's no one size that fits all. Going back to how we started this conversation, that estate planning is designed to be very customized. So these are good exercises, these are good discussions for every family to have to determine whether or not their goals are best set forth using a vehicle like a revocable trust, or is it better to just have it utilized by a will, understanding that there will be some work and time and paperwork that will be necessitated on the back end. And the second issue, to kind of now complete the thought, is that one of the things I find in all my years of doing estate planning is that, you know, people are very quick to define the family members that they would want to leave money to. But it's interesting that when I ask them the question, well, do you have any friends? Do you have any other individuals that are so meaningful in your life that you would want to leave money to? And it then begs the question of, Well, do you have any charities, whether it be churches, other nonprofit institutions? And just for the sake of discussion, how about the University of Maryland? A very worthwhile nonprofit organization that does a lot of good. And it's interesting in all my years of doing this that people oftentimes look at each other, scratch their head and said, huh, I never thought about that. Well, this is, again, I think another issue that people ought to be thinking about in the context of their estate plan. Beyond their family is, do they want to leave assets, as I said, to other individuals or from a charitable standpoint? And that can, look very simple. If we look at charitable giving, and I could say I want to leave a specific dollar figure, $100,000 to the University of Maryland. I want to leave 1/3 of my estate to the University of Maryland. Very straightforward. And then I could even get more sophisticated. If I want to have and set up a scholarship fund, I want to set up an endowment that would help the university. There's lots of ways that that legacy can be effectuated. One of the things I have set forth in this slide is, a very common way of providing a way to give charity, not from an immediate standpoint, but kind of a way to give well beyond for many years to come, using donor advised funds. And these are accounts, funds that you can donate to, getting a charitable deduction. Those are ones that you can set up during your lifetime and make donations now to get a charitable deduction. They're ones that can be funded at time of death. Instead of having funds being given immediately to a charity or charities, that you can actually set up, think about this as almost like a private foundation. Although that's a term of art when we utilize it, but it's a more streamlined, easier way of being able to collect funds and being able to give direction to family members or friends to carry out your charitable intentions and to distribute funds over certain periods of time to different organizations, to different causes, and to be able to monitor whether your charitable intentions are being properly honored and whether we want to buttress that, we want to reduce it. And again, it's a way, much like we talked about in the context of a trust, having control from the grave, donor advised funds can really provide a very nice vehicle. So for those of you that are very interested in those type of conversations, obviously most charities, think about the University of Maryland, have wonderful Office of Gift Planning personnel that can really help you define those goals and can really help think about the right vehicle that can be utilized to effectuate your intentions. So up to this point, we've talked about, again, at such time that you or a loved one passes away and the importance of a will, what happens if you don't have a will, how you can leave assets to someone either outright or in trust, and whether that's advisable. We've talked about taxes. We've talked about whether a revocable trust to be utilized. We've utilized and thought about beyond our family, friends, and charitable giving. And so I think that kind of defines, I think, the key salient points for what I'll call death planning and preparing for that eventuality. But part and parcel with a good estate plan is we also have to deal with a situation that, not that we've passed away, but a situation that we're alive and we're unable to make our own decisions, usually because of some type of cognitive impairment.
And Raj, actually, before we go into the next section, if I can just interject with a couple questions here. We have a few that are coming in, and before we get too far away from the topics, I wanted to see if we can maybe answer a few questions. Is that all right?
That would be great, please.
Great. So here's a question. What should I ask an attorney before I hire them? And what are the average costs to put together an estate plan?
I think that's a great question, Jeff. And actually, at the end of our presentation, we actually have a recap, and I'll talk about that very issue. And then I think it'll make probably more sense once you understand what the scope of an estate plan is, but I definitely will talk about the process of getting the right people to help you and giving you a sense of what the cost will be.
Great, thank you. There were a few questions about cost, so anyone else who was asking about that, we can hold off for a little bit.
Okay.
And I have another question here from Agnes Ann. If I set up a revocable trust in Maryland, but let's say I move to another state, does the revocable trust remain intact?
Great question. And even a broader question is, aside from even a revocable trust, I have a will, I have other estate plan documents, and I move to another state, are they going to be honored in another state? Typically, generally speaking, the answer is yes. There's a lot of reciprocity from one state to the next. But having said that, as you've probably gotten a sense already, state law does vary, even when it comes to something as simple as inheritance tax. So what I would recommend is that when you move to another state, even though the documents are by and large going to be valid, it would be advisable to have a practitioner and advisors in that state look it over to see if there's anything particular to that state law that would necessitate some updates. And one of the more simple ones is, what law would apply to the administration of that trust if I pass away? So if I'm in Maryland and I set up the trust in Maryland, it would be under Maryland law. If I move to Montana, then I probably would want that to be subject to Montana law, and so oftentimes we just update the revocable trust just to reflect, what state law would govern the administration of the trust should a dispute or a problem arise. And that could be just a very minimal amendment that can be made to the trust. But again, I think the bigger picture is just have someone look at it and make sure there's nothing that needs to be updated because of, unique or peculiarities to that particular state law.
Thanks, Raj. We do have a few other questions, but if you want to keep going, we can make sure we can get through all the content in the hour.
That'd be great, and we certainly will hopefully have some time at the end to tackle. But I definitely will talk about the cost and process standpoint because of the number of questions on that topic. So again, on the topic of what we call disability planning and just talking about a situation you can't make your own decisions, needless to say that without proper planning, it can be a real disaster. You have spouses that need to take care of paying the bills, refinancing mortgages, signing tax returns, perhaps having to make medical decisions, and without proper planning, they oftentimes find themselves in a situation that they can't do it. And a lot of people say, well, I can do it because I've been named as the executor under the will. And they find out the hard way, well, an executor, a personal representative, their powers, their authority only takes effect when someone passes away. Again, we're talking about someone who has not passed away. They can't make their own decisions. So the will has no bearing to this conversation. And what ends up happening is that they end up having to go to court. And the court will have to declare their loved one incompetent and then appoint the loved one to be able to assume the decision-making authority, and that's called a guardianship. Again, court is time-consuming and expensive. So with that being said, the proper planning is to do what's called a power of attorney. And just in this most simplistic, and I'm not going to go into a lot of detail because I find that most people understand conceptually what a power of attorney is. Basically the piece of paper that says, if I'm alive and I can't make my decision, here's who should make my decisions for me. And typically there's two types of powers of attorney. One that would be a financial power of attorney, who would pay my bills, file income taxes, and the second would be who would make my medical decisions, who would talk to my doctors for me. And what I really want to focus in on is, again, not only the importance of those documents, these are documents that everyone should have, regardless of age. And the big issue that I find people getting hung up and I think missing the opportunity is really giving a lot of great thought and care as to who should make the decision. The person or person that you designate under this document is called an agent. They're the ones authorized to handle the decision that you entrust in their hands. And if I go back to my example of my gentleman that I alluded to with those 3 kids, what he said is, well, remember, Raj, my eldest daughter is my superstar. She's my go-to person. And I'm going to name her to make sure that she can handle all of my affairs. And I say, Mr. Smith, I get it. But what do you think the other 2 kids are going to say when they find out that they're not involved in the decision-making process? And he quickly says, oh, you're right. They're going to be very hurt. And frankly, they might be upset at my daughter, and it's going to cause a lot of family conflict. So you know what? I'm going to name all 3 of them. And I said, well, Mr. Smith, I understand what you're reacting to, but remember when we talked a few minutes ago and you said they were fighting over Thanksgiving dinner over what gravy to use on the turkey? Are they really going to be able to make critical decisions for your finances and your medical care when they don't even get along? And the point that I raise is not to say which one is the right answer, but to make sure that you give great thought and care to ensure that the person or persons that you appoint are the right ones. Is this plan going to work? Is it going to cause problems? Is it going to cause conflict? Because at the end of the day, we don't have a do-over if something happens to you. And you need to be very thoughtful and very honest with yourself and your advisors and your family. And this could necessitate family conversations. This could require the writing of letters. And the other point about powers of attorney, and this will all be, somewhat basic, but yet people overlook this important point. To make sure that if you do it, to make sure your family knows where to find these documents, the fact that you've done it, what good is these documents if an emergency happens and they can't find it? And so it becomes very, very important that you communicate to your family. And the other point I should also add is that these documents, as I said at the very outset, are not boilerplate. And would you be surprised, for example, that a very broad power of attorney could allow the person to move and transfer the house to themselves as a gift, change the beneficiary on a 401k or IRA? So think about my situation that my gentleman adds his eldest daughter. And she says, you know what? I'm doing all the work. No one's here to help me. I deserve the house. I think I should be the beneficiary. And she changes it. And the document allows her to do that. So that could be a source of a tremendous amount of conflict. So the question is, should I have that power? Should I take it out? Should I have maybe a disinterested party as opposed to the kids taking care of it? Again, the point of this is to have a very customized discussion to ensure, again, the decision maker, but also the scope of their authority. One thing I should add, and this will be directed to my younger couples in the audience, one of the things that we would have in a will is that if you have young children under the age of 18, who would take care of them? Who would assume responsibility? Who would become their guardian? Who would you entrust them to? And you oftentimes have a provision under the terms of the will that would say who you would want to appoint. One of the things I find missing almost universally is what happens if you're in the hospital, you're alive, but can't make your own decisions? Who's going to assume the responsibility of your child or children? The provisions about guardianship should also be delineated under the terms of a power of attorney. And I find that more times than not, there is no discussion whatsoever about that critical point. So for those of you that have a young family or think about having a family, do not overlook that very important point. It can make a world of difference as to who can take care of your children and versus having the conflict that may ensue when that's not delineated. So as we sort of are now getting down to our last 10 minutes in the presentation, and as I said, I wanted to make sure that we have some time for some questions. A third aspect, and I'm not going to spend a lot of time on this aspect of the discussion, but again, this might be focused more on folks that are more thinking about retirement and a little bit older, and the concern there being, what happens if you become very ill? And again, this conversation could also apply to those of you that have perhaps parents that are aging. But what happens if someone takes ill no longer can care for themselves and they need a nursing home, they need assisted living, or a caretaker to come to the house. I don't think it comes to any great shock to anybody that that care can be very expensive. And what I find too often is the first time that people talk about how to deal with it is when the crisis hits. Raj, I'm at the hospital. They're telling me that mom has to go to the nursing home, and they're saying it's going to cost me $10,000 to $12,000 a month. What am I supposed to do? That's not the time to make careful planning decisions. So that's a discussion that people ought to be having. Do they have enough assets and income to defray that cost? Will other members be able to supplement the cost of care? And there is a financial product that I'm a big proponent of, at least to discuss to see whether or not it has a role in everyone's plan, and that's long-term care insurance. And that's a special type of policy that you would purchase. And the purpose of that is to pay a certain amount towards the very care costs that we've just been addressing. Again, it's not for everybody. Some people say, I've saved money, I'm going to utilize my savings, and if I get it all depleted and used up, well, so be it. I took care of my kids, they've got a great education, I've done my job. Some people take the contrary view to say, I want to leave a certain amount to my family, and if long-term care insurance will allow me to shelter and protect my assets for a greater legacy to my family, then that's something that I believe in insurance and I'm willing to pay for it. So it's something that would necessitate a good conversation with your financial advisor to think about different options and to see whether or not it would have a role in an overall estate plan. So as we wind up here in the last couple issues, just a couple miscellaneous issues. One is we've talked about a good estate plan and all the nuances and things you need to think about, but nothing suffices for a good plan that's communicated to your family. And I use this cartoon because the one thing I find is the one time that families are together now is Thanksgiving. And I know it's a time of joy and festivity, but it's also a great time to have conversations such as, Mom or Dad, or son or daughter, if I'm in the hospital and I'm in really bad shape and there's no chance of any type of recovery except for using the machines, I want you to know that I've executed a living will, a medical power of attorney that says I would not want heroic measures. And I just want you to hear that and know that, and to know that if push comes to shove, please, to terminate life support, that you'll be honoring my wishes. What a powerful statement that is, as opposed to coming in cold and not knowing that issue. And I find that one of the things that I find a lot of families doing now is actually doing what's called a letter of intent. Obviously, the legal documents will have their role, but I have a lot of families that will write their own letter to their family. And they'll say, this is what I would want you to do with the money. Or to my siblings, if you're serving as a trustee of my child's trust, this is my value system. These are my hopes and dreams for my kids. This is what I want you to utilize, how I want you to utilize the money I leave behind to benefit my children. And just as emotional and just as difficult, a message to the kids. Kids, I'm sorry I'm not going to be there for your graduation to see you get married. And I'm not going to be there to give you that life advice, but let me give you that life advice now because I'm not going to be here to do it. And remember the value, remember the history of our family, whatever that looks like. What a powerful document, a legacy document. Again, no legalese involved. That's straight from the heart, and there's no format, but it can be a very powerful document that can really supplement and buttress a good estate plan. And then the other aspect is, and directing more to those of you that perhaps have an estate plan, do not overlook the role of technology in our life. It used to be that our assets were very simple: house, bank accounts, stocks, life insurance. But what about all of the pictures that are in iCloud? What about our email? What about all our social media accounts? What about the emails and everything I say, PayPal accounts? What about the websites that I own? Not only could that contain money, but they may be valuable and maybe even some of the most valuable assets that we own. Unfortunately, the law has always been a little bit slow to catch up, but the law now is evolving to be able to give executors and agents under these documents more authority to be able to access it. Programs such as, if you think about Google, for example, do have terms of service that will allow you to designate online the people that can assume control of your account if something were to happen to you. Great thought and care needs to be given to that, not only in the documents, but also I have a lot of clients that will write that out to ensure that their family member knows that those assets exist and how to deal with that. And that's one of those situations that we didn't talk about 10 years ago. But because life has evolved, it becomes very important. So as we close up here, in the last slide here, we've set forth the documents you should have, looking at the assets. And of course, the big question is, Raj, I buy into it. I'm motivated to make this happen. How do I make it happen? As we said, it comes really to a good team of advisors. A good attorney, good financial advisor, good accountant, oftentimes are working together, but more times than not, a good attorney that is an estate planning attorney that deals with these issues day in and day out. And my best advice and recommendation is that there is really, at the end of the day, a finite number of estate planning attorneys that truly do this line of work. And I think the best way of gauging is two things. I think word of mouth is always the best way. Talking to other people, talking to other advisors, accountants, financial advisors, friends and other family members that would be more in the know, that would know who they've heard are reputable and do good work versus the ones that perhaps, are not as reputable, for lack of a better word. And then I think the other aspect is to talk to the attorney. This is a very personal decision. This is someone that really will be a key advisor for you and your family for now and the foreseeable future. They oftentimes are the person that will be there for your family in the event of an emergency to help implement this plan. So talk to them. See who you feel comfortable, confident in. And of course, the big issue is fees. And the reason I deliberately didn't put a slide to talk about fees is that it's very difficult because lawyers do charge in many different ways. Some do strictly fixed fee basis, a set fee for the preparation of all the documents, all the meetings, all the follow-up to do beneficiary designations. I would say that I've seen everything from, and again, it depends on the complexity of the plan. Basic plans will be, a certain amount. More complex plans, because of trusts or maybe because of significant tax planning, will increase the cost. So, for a more basic, package, where we don't deal with trust, I would say that the average cost probably would be somewhere between, 600 to 1,200. Again, doesn't mean that the person who's 600 is, bad. It doesn't mean that 1,200 is the best. Again, every attorney, even the best ones, can be on the lower end, and some of the worst ones can be on the higher end. But you need to feel it out. You need to find out their reputation. Word of mouth will give you that peace of mind. For couples that have young children and want to have the provisions for guardianships and trust for kids, I find that the cost can be somewhere between 1,200 to 2,400, 2,500 on average, and then it could run up from there if you have more significant issues in your family, more tax planning. But again, openness, it's incumbent on attorneys to be very open under the rules of professional conduct, but that should be a conversation that should be had at the outset. And look at it as an investment. I know no one likes to spend money. I know there's lots of other options of getting forms at Office Depot, online, but I will say, and I know this will seem self-serving as an attorney that does estate planning, but there is no substitute to the live personal discussion. As we said at the very outset, I want to know your hopes, your dreams, your concerns. I want to know the family conflict. I want to know everything that is there to know about your personal and financial situation so I can make the most effective, most customized, effective plan that's going to work for you. And at the end of the day, that's what the most effective estate plan is all about. And if I have inspired you, encouraged you to get an estate plan, update an outdated estate plan, then my success is that then this presentation did and achieved its intended result. And I hope you've all found great benefit in the time that we spent together. And thank you for spending this time for the last hour. Jeff,
Thank
I
you,
know we're right at
Raj.
1 o'clock, and I don't know if there's some questions or whether we need to wrap things up, but I'm certainly happy to answer any questions, and I'm happy to stay on a little bit longer for those of you that are able to hang on, and for those of you that have to drop off. Again, thank you for the time in joining us, and again, we hope we found this time worthwhile and helpful for your family.
Thank you, Raj. We'll try and answer just a couple of questions here, and then for anyone who's submitted a question that we don't get to answer, the Office of Gift Planning will follow up with you directly. But here's one from Tom. How often should somebody review and or update their estate planning documents?
Yeah, Tom, when it comes to updating estate planning documents, I always recommend that, at a minimum every 3 years, 3 to 5 years. I think it's a good point just to look at them. And just check in with your advisors to see if there's any changes in laws, but more importantly to see if the people that you've designated and how you delineate your wishes still make sense, because those wishes will evolve obviously over time. So I would say every 3 to 5 years, unless a situation arises that forces the issue more sooner.
Great, thank you. And from Andrew, can a trust be kept private from all parties, including beneficiaries?
Andrew, that's an interesting question. For many, many years, one of the hallmarks of a trust was the sense of privacy. It didn't have the documents, didn't become public, you didn't have a layer of disclosure. Under recent changes in law, again focusing on Maryland, the Maryland Trust Act, the concern that was expressed by the state legislature was that there was too much privacy and that people that needed to know were not being provided proper disclosure. So it's chipped away from the privacy, but there is actually legislation that's being considered by the General Assembly. I think you might hear more about it in next year's General Assembly to kind of get that happy medium of disclosure, but at the same time, there are valid reasons why people want to have privacy. So so my answer to you is that it's a little bit more challenging than it used to be, but certainly not insurmountable. And there's obviously other options that I would implement to try to avoid having things get out in the public domain if the client's primary goal is to preserve and protect privacy.
Great, thank you. And we've had a couple of questions kind of along a similar line here. And one here is, can I have a notarized letter of intent stand in place of a will? Or similarly, can I draft a will on my own, or do I need to do this through an attorney?
Yes, again, not to be self-serving, but there are certain formalities that a will needs to comply, and that's set by state law. Failure to comply with those requirements will invalidate that piece of paper. And just because you sign a piece of paper and notarize it and say, this is what I want, more times than not, I would almost say 99% of the time, it will be invalidated and not treated as a will. So again, that's where it becomes chaotic. It can be more expensive for the family. Consider this an investment, a low-cost investment to ensure that things will go smoothly and ensure that your wishes are properly honored, and do it through the use of professional advisors who can ensure that it's going to be done right.
Great, thank you, Raj. I think that was going to be where we'll have to cut off. As I mentioned, the Office of Gift Planning. We'll follow up with anyone who had a question that we did not get to answer. But I want to thank you to Raj. This is a great session. And thank you to all of our Terps who attended today's webinar. A recording will be emailed and also posted to the Smith School alumni website. We'll be going on a break for the summer holidays, so get out there and enjoy some fun in the sun. We'll restart the webinar series this fall on September 12th. with a session titled Becoming a Savvy Startup Investor. Join us to learn about early-stage startup investing from Alana Fine, Managing Director of the Dingman Center for Entrepreneurship. Stay tuned via email for more information. Thanks very much. Have a great day, and go Terps.